Oh, thank you for having me here. Thank you very much. I'm really excited.
No.
Yeah.
We are very excited, and it's really a pleasure having you here. Thank you very much.
The pleasure is completely on my side.
Just waiting for the students to come in.
Yeah.
Only 5 minutes, and I'm allowing everybody inside.
Christoph, Professor Simão sent us a message that your sound is very low. If you could raise the volume there, I don't know how, or if otherwise you could just get closer to the computer.
Okay, I did take the earphones. I have separate earphones. I thought it may be better with them. Do you hear me, Rui? Do you hear me?
Yeah,
well?
but you could speak a little louder, or
Yes,
be closer to the mic eventually.
maybe take off the mic. Maybe it's better with the laptop itself. I just tried that.
Yes, yes, I think so. It's too low.
Okay, how is this? I'm on the laptop now. I have no earphones in. Is it better?
Much better now.
Yes.
You could even sing.
Much better. Okay.
You could even sing a Wagner aria now.
I would love to, but I think you wouldn't love me to sing for you. So we keep to what we've learned. I wouldn't say we keep to what we're able to do, but at least to what we've tried to learn.
Okay.
I would like to thank that we have here Professor Satiro. Professor Paulo César Aragão is here too.
Good morning.
Renata Maciel. And Professor Simão, I can't see you, but I'm sure he's here. Okay, so I would like to say hello to everybody and thank everybody to be here. Hi, Professor Satiro. Nice to meet you too.
Hi, good morning, everybody. Good morning here. Good afternoon in Germany.
Good morning, Professor Satiro. Very nice to see you.
My pleasure.
Yeah, the number of students is increasing by the second. We already have 100 people in. Professor Juliana has just connected. She was with you in Munich last year.
Yes.
Oh, yeah.
Hi, Professor.
Oh,
Grigoleit.
hello.
How are you? Fine, thank you.
I'm fine, thanks. Good to see you again.
I'm very happy to be here. Thank you. Thank you, Professor Paula, Rui. Thank you.
I'm so impressed that you all made it at this time in Brazil. It seems like usual, the Brazilians are the real Germans. They get up at 7:30 just for a lecture on doctrinal matters. This is so impressive. I don't know how you made it. I wouldn't make such a arrangement in Munich. I wouldn't dare to, but I'll try hard to make up for it for everybody.
Yes, thank you. We are waiting for Are we waiting for Floriano, aren't we?
Yeah, Floriano will be joining us. Floriano is the Dean of Law School, Professor Grigoleit. He'll be greeting you.
Oh, that's very kind of him that he got up so early just to say hi.
Yes, and well, probably he'll be joining us in a few minutes. Let's see. One more thing, Professor Zanetti is. I also sent a message to Professor Zanetti. He will be probably joining us too. And it seems that you, Grigoleit, yes, Floriano, and Zanetti have a coincidence. The three of you are fresh fathers. You've just had baby boys in the three cases. So Zanetti has had Pedro like a few weeks ago. You had in last January, right?
January, that's perfectly true.
Yes, and Floriano, our dean, had Bento 2 weeks ago. So we can already arrange for a derivative.
Perfect. We shift from change of circumstances to child raising, which brings me to another point. I'm in my home office here, And apart from this newborn baby, I've 3 little children here in the house. Even though I closed up my room, it's not completely excluded that there'll be some noise and some rioting in front of my door. So don't expect a military coup to have taken place in Germany. That's not very likely. It's just my children. They're really hard to control.
Well,
Don't worry about that. We are very used to that.
Oh, that's good. Brings me to closing out the door. I'm not certain whether I did. I'll check for it. I'll be right back.
I was closing my office too.
I did close the door, so.
no, but it's okay. You know, we have the tradition of showing the kids, dogs, cats, you know, the virtual meetings and classes.
This again gives me the impression that you are the Germans and I'm the Brazilian.
Well, I'm just going to send a message to Professor Floriano, telling him that we're waiting for him.
No problem. No problem.
Rui,
Oh, Professor.
I am here, hearing.
Where are you, Floriano?
Good morning.
Hi.
Great to have you here, Floriano. Great to have you. Thank you so much.
Good morning, Dean. It's a great honor.
It's for me.
Good morning,
No, for me.
Floriano. Thank you for being here.
Yeah. Paula, I think we can, Paula Satiro, I think we can all start, right?
Yes, yes.
We already have 100.
Yes.
The rest will be joining us in the following minutes. Well, good morning for everybody who got up early to be here for the lecture by Professor Hans Christoph Grigoleit. Professor Grigoleit is full professor of civil, commercial, and corporate law in the law school of Ludwig Maximilians Universität München. He is one of the most distinguished jurists in Europe, and also the author and editor of many important books. I will mention only 2 of his many works. He's the editor of the most important commentary on the German Stock Corporation Act, the Aktiengesetz, the Lei der Sociedades Anônimas. The commentary edited by him, by publishing house in Munich, has 2,300 pages. So it's a very substantial work, a very used work in an important piece in German legal literature. And I also recommend another book edited by him. This one was published by Cambridge University Press, and the title is Unexpected Circumstances in European Contract Law. You can also see by the title the relevance of the book subject at this time. Professor Grigoleit is currently Dean of the Munich Law School, and as such is in charge of the needed shifting of all the programs, online lectures, as we did in USP due to the COVID pandemics. The title...
Rui, só uma coisa, o teu som... Not good, I'm sorry.
Ok, vou mudar de novo. Paula, eu não consegui resolver esse problema ainda.
Don't worry.
Let me change place here.
No.
Okay. Is it better now?
E outra coisa,
Better.
a lot of microphones open. I think I would ask everybody to close the microphone, please.
Paula, is it better now?
Yes, it's better, but a lot of microphones open. Okay, sorry. Go on.
We can move on. So I was just mentioning, Professor Grigoleit is currently Dean of the Munich Law School, and as such, he's in charge of adapting and adjusting the school program to online lectures as we did in USP. And Professor Floriano is also having this task, this difficult task at this important moment. Well, the title of Professor Grigoleit's presentation is Change of Circumstances in Contract Law, a doctrinal approach to Corona. He was speaking to us from a historically relevant position. His successor in the same chair, the same literature, a mesma cátedra, of two authors who are essential references in the subject. The first is Karl Lorenz. Karl Lorenz has developed and systematized how Bergman's Geschäftsgrundlagentheorie, a teoria da base objetiva do negócio jurídico. He was also chairing the same chair of Grigoleit. And the second name, the successor of Professor Grigoleit, is Klaus Wilhelm Canaris. Canaris, many of you know Canaris by his book translated in Portuguese, Metodologia, conceito, pensamento sistêmico do direito, but Canaris also played an important role in the reform of the German law of obligations. And this extensive reform of the BGB of the German Civil Code, the doctrine of Geschäftsgrundlage, teoria da base objetiva do negócio jurídico, was formally incorporated into the German Civil Code in Article 313. Christoph, guten Tag. Thank you so much for having you here, for taking some time out of your busy schedule. You'll be speaking to 30-year undergraduate students and also to some 50 master and doctoral students, apart from the professors that we have already greeted. And before giving the floor to Professor Grigoleit, I'd like to invite Professor Floriano, the Dean of our law school, to say a few words in order to greet our special guests. But I cannot refrain from directing everybody's attention to a very happy coincidence involving both of our deans. They are both fresh fathers. They have both had baby boys recently. Ulis, the fourth boy in the Grigoleit family, was born last January, and Bento was born to Professor Floriano and his wife 2 weeks ago, and this is one more reason for which we thank Floriano for being here with us after probably a long night of work, changing diapers and all that. Well, Professor Floriano, please, the floor is yours.
Professor Grigoleit, my Deutsch ist ein bisschen verröstet und vergessen. Deshalb werde ich auf Englisch sprechen. Bitte. Yes. Entschuldigung. I am very happy to have Professor Grigoleit today. The professor, as Rui told, it's a great friend of our faculty. We are always welcoming our academics when in Munich. In addition to being one of the most important private law today in Germany, and Professor Grigoleit, I hope this participation will serve to bring our faculty even closer from the University Munich. I am sure that this event is the first of many to come. Paula, Rui, thank you very much for hosting this event. And Professor Grigoleit, I am closer than you because we are living the same experience with a little baby at home. But a little baby is always a good news, and great opportunity to restart our experience as fathers. Then I wish you all to take the opportunity and learn a lot this morning. Unfortunately, I should go soon because I have class later, but I believe that we will have a very good event. Professor Grigoleit, once more, thank you for your participation. Rui.
Okay, Professor Christoph, before you start, please, just one last remarks. students can make questions during the presentation using the chat, and the students can either choose to write in English or in German if they speak German. And if those who are not so bold, if they want to write the question in Portuguese, I will translate it in the chat. And it's up to you, Professor Grigoleit, to decide whether you're going to answer the questions during your presentation or prefer to leave them to the end of it. And please, Professor Grigoleit, you have the floor.
Many thanks, Rui. Many thanks, Professor Floriano. I'm really so proud to be invited to this talk, and I'm very grateful for your warm words, which were quite flattering to me, even though as far as my person was not concerned, they were all true. I would like to first comment on what Professor Floriano said and Rui mentioned as well, and this is the long-standing communication and long-standing friendship that we have between the two faculties and between many of the colleagues of the two faculties and our Munich faculty and my person. And I would like to stress, in particular at these times of a worldwide crisis, that this international communication, and particularly the communication between the two countries and the two universities, is extremely valuable to us. And if Corona has one upside, then it might be that we've become so close via the technical tools that we get used to using these days. And therefore, I'm really grateful to have this opportunity to speak to you today. Also, I would like to welcome the students in class today, and I would like to start with a little commercial as far as they are concerned. We regularly have students from USP in Munich, and I get to talk to them and get to work with them frequently, almost every year. And I can tell you, I'm again very grateful that we have them. It's almost always the case that they're extremely excellent. They're excellent and they're doing extremely well in the German system. They learn German very well, and they contribute a lot to classes and with their written works to academic writing. So I would like to motivate you who are listening to me today in the lecture. Think about coming to Germany. Think about maybe even studying this difficult language. Professor Floriano also already started in German. Rui also said hello in German. I know it's hard, but it's probably not as hard as getting up at 7:30 in the morning in order to get a doctrinal lecture from Germany. Okay, this brings me to the start and to the topic that I would like to talk about today. And the topic is unexpected circumstances, change of circumstances, and their consequences in the law. I have defined the lecture as first dealing with the doctrinal approaches to change of circumstances, and second, to the current issues that we all deal with in the context of the pandemic, in the context of COVID-19. And we have learned in Germany that the pandemic is really hard on Brazil, and we are we're feeling very solidaric. It might be that in Germany we are a couple of weeks ahead in the wake of the pandemic, so we can only hope for you that you get through these very difficult days, and through contact restrictions may get better in the near future. So if we talk about contract law problems considering COVID, then we get to my presentation. I've now opened up my presentation on my computer. Can I make it seen by the audience?
Yes, there's it's written in Portuguese. Apresentar.
Okay.
To the side, to the right side. If you press that, you'll be able to see your screen.
If I press the
Apresentar. Yes.
Presentar. I don't see it yet.
Let me see if I can.
Here. Okay, I see.
Yes,
it.
apresentar. Yes, we will be seeing your screen when you press that.
Do you have it now?
Let me see. Just a second.
It's opening.
It's opening. Okay, good.
We have it.
Let's be an opportunity to mention questions during the lecture. I'd really love to take questions, and probably it's best if you just pose your questions whenever you feel like, and maybe I get a little bit of help as far as the reaction on questions is concerned. Maybe Paula or Rui will give me a hint when there's a question.
Okay.
Everything okay? Do you have my? Is the presentation visible?
Professor, something happened to your sound. It was very good, and now it's not that good. Did you change something?
No, I didn't change anything. Is it better now?
Let it be. Okay.
Is it good now?
Yes.
Yes.
Professor Grigoleit, just one more reference. We are having the Professor Ana Frazão from the University of Brasilia has also joined the class, and we also salute her.
Professor. It's an honor.
And also Professor Rodrigo Mendes is here with us. Good morning, Rodrigo. Good morning, Ana. Very nice to have you here.
Good morning to everybody. I'm really proud that you're here.
Thank you very much. It's really a pleasure to hear you again, Professor Grigoleit.
Thanks. My pleasure. Pleasure completely on my side.
Good morning, Professor. It's really a pleasure.
Good morning.
Thank you.
My pleasure. So, is the presentation visible to you?
Yes.
Okay, fine. Then I'll just get started. Do you see me still, or only the presentation?
We can also see you.
Okay. Too bad. I was considering to take off my shirt, so I'll leave it on. So let's start with the presentation, and before we get into the cases of COVID-19, let's find the starting point. We're in a lecture here, so I'll try to pick up every student. And when we approach problems like those contractual problems that relate to the pandemic, it's always an issue of pacta sunt servanda, of the binding nation of the contract. Whenever the pandemic plays a major role, it'll be an issue that will somehow challenge the binding nature of the contract. So as a starting point, we can all, just memorize what we all know, that pacta sunt servanda is a fundamental principle in all legal system that we know, and it's based upon individual autonomy. If parties are autonomous in entering into contracts, then the binding nature of the contract is the reaction on this autonomy, is the tool to connect the autonomy of two different actors in one legal instrument. Also, pacta sunt servanda is a conditio sine qua non, is an essential element of market autonomy, and one could call it the flip side of individual autonomy, that everybody is responsible for what is stipulated in the contract. And also, I would derive from pacta sunt servanda a general duty to endure hardship, which means whenever I enter into a contract, I have to take into account that the consequences of the contract may lead to some kind of hardship, may be less beneficial than I may have expected when entering into the contract. So this is the starting point, and this starting point in a second step leads to certain statements on risk allocation. And these statements of risk allocation have to start that by the statement that the validity of contract is not conditioned upon all possible expectations the parties might have when they enter into the contract. There's no implicit condition to a contract that what a party expects becomes true. Thereby, it follows probably in every legal system we know of that the parties assume by the contractual setting certain risks that are clearly the consequence of the contractual exchange. And these risks are that the supplier of goods or services assumes the risks that the costs of the supply increase. If his costs become higher, then it's his problem and not the problem of the customer. And the customer assumes on the other side the risk of making use of and commercializing the goods and services he receives. So these are the two basic risk assumptions that we always have to start when we deal with exceptional circumstances and when we discuss potential exceptions to the binding character of the contract. Now, if this is the starting point, the aspect of risk allocation, then of course one has to take into account that there are limits to any meaningful stipulation and to any meaningful risk allocation. And this is that it is impossible for the parties to assess any kind of future events possibly relating to the contractual exchange. So there will always be important factors, important events that the parties cannot take into account. Also, it is, or in particular, it is to be noted that, in particular, some very rare but very effectful events are beyond any meaningful risk allocation, which goes to say that war or any kind of legislative intervention, economic crises, natural disasters, and of course pandemics, these are events that people may think of and that are within the awareness of intelligent parties, but it is definitely not sensible to contract around these aspects as they are too rare and too difficult to predict. Therefore, all the legal systems that we know and all the European jurisdictions, the Brazilian civil code, have certain instruments, certain doctrinal elements that deal with unexpected circumstances and somehow provide for relief under certain circumstances. And this kind of relief, and this is one of the also very obvious introductory aspects, the standards for this relief must be and are always very restrictive. There's a considerable burden of argument for any kind of relief due to extraordinary circumstances, due to any exceptions of the regular risk allocation. So if we, from this very basic line, approach the doctrines that we will talk about later, I would like to introduce a very rough distinction. And this distinction is that there are certain doctrines that are, or certain instruments that are specifically provided for in the contract. And even though an event may be burdensome to one party, if it is specifically provided for in the contract, then there's no need to apply any doctrine relating to unexpected circumstances. also, if there's a one-sided, a clear one-sided responsibility or risk assumption due to legal arrangements or due to the contractual rules, there's no reason to refer to elements of to doctrines that relate to unexpected circumstances. So this is pretty much like a very rough introduction into the basic notions that underlie the doctrines that we will discuss today. I would now like, from this general point of view, to turn to typical COVID fact patterns. And I've defined three, and this may be the first moment where we really get into some kind of communication in this lecture. Maybe you can add other ones. My fact patterns are, first, that the landlord of a restaurant has to close his restaurant due to COVID legislation, and the issue is whether or not he's still obliged to pay the rent that he owes on the long-term contract, and or whether he can ask for some relief from this rent. I bet that this issue is relevant in Brazil as well as in Europe. Another fact pattern would be, and this is maybe relevant for each of us individually if we
do some sports, the customer of a fitness studio cannot use the fitness studio anymore because it's closed due to COVID regulation. And the issue is whether or not he then can withhold the monthly fee, or whether he may terminate the contract because he will not get the contractual performance anymore from the other side. And here we have the direction is a bit reversed. The usual consequences under contract law would be if the customer does not get his contractual performance, his claim, then of course he can withhold the counter performance. He can even possibly terminate the contract. The issue here is, are there special rules due to COVID-19 in order to protect the studios to get through these difficult times? The third fact pattern, and the last one that I will present, and you may present some, is a contract that is concluded late in 2019, under which the seller, who's a wholesaler, promises to sell certain medical equipments, and these medical equipments he plans to procure in the year 2020, and maybe he
has to procure them in China, and maybe at the beginning of 2020 is opportunities to buy the equipment in China was
reduced, and the price was increased. Even as I put it in the fact pattern, even maybe
10 times as much as he expected, and therefore his own contract with the buyer. Yeah. Yes.
The mic, there's a problem with your mic. Maybe if you bring it closer, because at a certain point, at a certain moment, your voice got really better, and then.
Okay, I will try to get the special a separate mic. Let's see whether.
Let's see. Yeah, because it was good, then it got a little worse, and now it's better. Now it's worse again. So I don't know. Wait. It's better. Maybe a little louder though.
Is it better now?
Yes.
Do you understand me?
Yeah.
I've now taken my extra earphones.
Okay.
Do you understand me?
Yes. Okay. Is everything fine? Everybody is hearing, is listening to him? Paula, tá ouvindo bem?
Not that, não tanto, oscila muito, né? But it's okay. I think if Professor talks very near to the microphone, it would be better.
Now very near. Is it good right this, Paula?
Yes, it's better. It's better now.
It's better. I'm really taking the microphone to my mouth right
No,
now.
now it's good. I'm sorry. It's working.
Like
yes, it's
okay.
very good.
We'll try everything. Please, as soon as it gets worse, tell me. I'll do everything to make you happy.
You're very nice. Thank you, Professor.
Okay, did you get the first and the second case, or do I have to repeat the cases?
No, it's okay. It's okay.
Okay, the third one was the wholesaler case who was facing a tenfold increase in his procurement prices, which renders his own contract with the buyer ruinous, and he is asking for renegotiation. And these are the three fact patterns that I would like everybody to think of when we wonder, when we go through the different doctrines and try to find out how and if and how we may grant relief to a burdened party. But before I go to the doctrines, I would first like to ask whether or not you have other and additional typical cases so that we can have a look at them as well.
Christopher, we had some problems with energy contracts, or also with gas contracts, because these are contracts in which you set a price for long term. And of course, the demand for gas and energy fell very much, and the prices also fell a lot.
Oh, so the issue was there whether or not this profit has to be returned to the customer. Is that true?
We're talking business-to-business contracts, between the energy firm and a factory, for instance.
Okay, and the factory wants to have lower rates because the supplier enjoys lower prices, right?
No, because the demand fell a lot, and also the price in the free market fell a lot, and they're bound to pay like 10 times the average, the current market price. For instance.
Okay.
It's probably take or pays.
Okay, and is that can you identify this also as a windfall profit for the for one party and a hardship for the other, or is it hardship for both parties?
No, it would be for one party because it's a take or pay contract. I mean, the party has to consume the energy, pay whether using it or not.
Okay, no, it's a very good case. We'll take it with us. Do you have another one, or do the students have another one?
Roberto Germanos is talking here about highway tolls that we are having a lot of problems too.
Okay, and what's the COVID issue here with the highway tolls?
Again, the traffic dropped down.
Okay,
and then you don't have the tools. You don't have as much tools as you used to have. So
it's a problem for the business who's running the highway.
Who's running the highway? Yes.
Okay, and they demand more money from the government, or where do they want?
We are starting to discuss all the problems. We are starting some arbitrations too. So the discussion is just beginning here.
Okay, but it's a really good case. I like that, the highway tolls. Any other case that we could identify?
Christoph, Lucas Barros has mentioned the issue of an M&A. And Professor Juliana, do you want to speak directly, Professor Juliana Pella?
Hello, Professor Juliana.
Hi. No, it's the same example of Lucas. M&A transactions between signing and closing, and COVID problems with the valuation of the company, or the material adverse change clause.
Okay. We'll speak about hardship or material adverse change clauses at the end of the lecture. That's a very good point, and probably very very universal and very often occurring problem. Okay, any other case? Okay, so if we have no more cases, maybe we can share more cases during the lecture. We can turn to the doctrines that may provide relief from contractual obligations under unexpected circumstances. And before we go to the doctrines specifically addressing unexpected circumstances, I would like to propose a distinction that has been very relevant for our work on unexpected circumstances that we did in the book that Rui mentioned, Unexpected Circumstances in European Contract Law. And in this book, we try to approach the issue by distinguishing all the potentially relevant doctrines. And it turns out that in the different legal systems, roughly the same cases would be addressed by very different doctrines. And some of them we qualified as conventional, and other ones we qualified as exceptional or unconventional. And the conventional doctrines, that were those doctrines who specifically try to identify the contract itself as the basis for relief, not so much the unexpected act or the extraordinary nature of the event. And the other doctrines went beyond the contract and explicitly addressed the unexpected circumstances and also the equity nature of any kind of relief. And these equity doctrines we called exceptional or unconventional. Now, as we will see, the unconventional, the exceptional doctrines will be most important in the context we have here. I would first like to turn to the conventional doctrines, because whenever something unexpected occurs, one may think of several traditional conventional doctrines they may apply. For example, doctrines of mistake. I have to admit that I'm not perfectly familiar with the Brazilian approach to mistake in contract conclusion, but I suppose it's rather restrictive. And even though theoretically one may think of all these issues of unexpected circumstances as a issue of mistake, it's not on a closer look, it's not a really good idea. The approach of mistake is to question the validity of the contract due to some material mistake in the process of contracting. And these issues of unexpected circumstances usually cannot identify any specific mistake. They rather refer to an implicit, very general expectation that the world basically will remain as it is. And this very rough and broad expectation is not accurate enough to apply any meaningful doctrine of mistake to. The second approach would be constructive or implied, constructive interpretation or implied terms. And this gets a little bit closer to what many judges have done in the last decades and centuries, trying to find some kind of implied will of the parties if their contract tackles unexpected circumstances like the pandemic or war or government intervention. And this doctrinal approach, pretty much like the mistake approach, tends to respect the contract, or at least the notion of contract, because it tries to allocate the resolution within the will of the parties. However, this approach, this reference to the parties' will is usually quite arbitrary, because there is no specific will of the parties to address an event that the parties actually did not expect. Therefore, this idea of interpretation is not a very meaningful doctrine in approaching unexpected circumstances. Another very broad and traditional and very old concept is the idea of lesio enormis, which, as I suppose, can even be touched in the Brazilian BCC. I think it's Article 317, if I'm not mistaken, that is very close to this idea. And the idea is that the relation between the obligation and counter obligation, the value of the obligation is extremely disproportionate, has changed disproportionately. And that is something that is already very close to what we will deal with later in the unconventional, in the extraordinary concept. This lesio enormis idea is that the contract itself only provides for a certain for a rather balanced approach to obligation and counter obligation, which is a basis that is left, that is exceeded if the values change. So the idea is focused on the contract itself, but at the same time trying to leave the basis that a disproportionate result occurs. Again, this is very close to what we will deal with under the unconventional concepts, and I will only mention here that I do not see a clear distinction to what we will deal with later as typical hardship legislation. Another concept will be impossibility of performance in force majeure. That is, these are concepts that try to relieve a party from an obligation due to unexpected events, and these events are very similar to what we'll deal with under hardship aspects later. There is, for example, in the Convention on the International Sales of Goods, a specific rule on force majeure. It is important to note, though, that impossibility or force majeure is not a doctrine that is in its usual form well suited to deal with hardship cases, because it is one-sided. It is an all or nothing approach. It is meant to provide a relief from an obligation, but it does not provide for any kind of balancing of results, which, as we will see later, is very important for providing meaningful legal consequences in the event of unexpected circumstances. But what we can take from here is that lesio enormis and force majeure are probably the traditional doctrines that are closest to what we will deal with under the unconventional concepts. To sum up the conventional doctrines is what I already said, that these conventional doctrines somehow base certain resolutions on the intention of the parties and somehow deal with certain flaws in the mechanism of contracting. And this apparently very strong connection to the contract is making them, for judges, probably very attractive, as judges tend to refer to traditional concepts and to try to achieve most stable basis in the party's will. Therefore, these conventional concepts have something what I would call a harmonic tendency. They are probably easier for judges to refer to because they do not have to openly challenge the contract. They do not, the judges do not have to set aside the contract and try to find a balanced solution and adjustment, as we will see later. So this harmonic approach of the conventional doctrines is their advantage. The disadvantage is that there are many assumptions taken here in these traditional views that are fictional, that tend to hide the real reasons behind the relief. They tend to conceal the essential equitable conflict that we have to solve. They tend to conceal the fact that the contracts we are talking about, for example, in COVID times, are usually flawless. They have no problem. They're working well. If it was not for the catastrophe, if it was not for COVID, they're flawless but silent. And therefore, we have to look for extrinsic solutions, solutions by objective law based upon equity, and all the solutions that suggest a closeness to the contract itself are, in these cases, rather fictional. The main problem of the conventional doctrines, however, is that they tend to only reverse the all or nothing approach. They tend, for example, like in force majeure, to relieve the debtor from having to perform. But they do not find a solution that is less arbitrary than what the debtor is incurring due to the unexpected circumstances. In other words, the traditional concepts exchange one arbitrary hardship by another one. They shift the hardship from one party to the other and cannot provide for a balanced solution. This is why all the modern codifications, for example, like the Brazilian one or the German one, or most European codifications, tend to recognize exceptional doctrines who directly address the issue of equity in unexpected circumstances cases. And here is an overview. I don't want to make this too lengthy. You probably have heard of most of the exceptional doctrines that we're referring to, and we don't have the time to get into them too closely. So one may turn to the doctrine of frustration of contract under the common law. One may turn to the doctrine of Wegfall der Geschäftsgrundlage, which is now under the German BGB, enshrined in section 313 of the BGB. And I will not, I will refrain myself from talking too much about it. Rui has already mentioned the influence of Professor Karl Lorenz on the development of this doctrine, also the influence of Professor Canaris on the German reform of obligation law that brought section 313 into the positive law. I just would like to mention that for section 313, it is elementary that it is a rule of objective law that refers to certain fundamental implicit expectations of the parties that we call Geschäftsgrundlage, basis of the dealing. And it is also elementary that, and this is quite special as in contrast to other jurisdictions, for example, probably the Brazilian BCC, that it does not distinguish between an afterward change of circumstances and bilateral mistakes of the parties. Fundamental bilateral mistakes that were already present at the time of conclusion are dealt just like changes that have occurred later. And it is, again, finally elementary for 313 that the expectations are not accounted for in the contract or in more specific statutory rules. Now, this German approach on Geschäftsgrundlage has been very influential all over Europe, and there have been some other tendencies that are in many aspects similar, even though maybe not completely identical. And this is in particular the Nordic doctrine of assumptions. This is more like more leaning to the conventional doctrines, trying to make what we call objective Geschäftsgrundlage to something impliedly put down in the contract, which is in this assumption idea. Infer certain assumptions in their contract, but there are many parallels to the idea of objective Geschäftsgrundlage in these Nordic jurisdictions. Also, in Spain and other jurisdictions, we have this idea of clausula rebus sixtantibus, a notion that stems from the medieval jurisprudence and is again very similar to the idea of assumptions and the idea of Geschäftsgrundlage. I don't want to get into this too much because in the end, all these doctrines are quite similar. I will get to the similarities later. I would only like to mention that the European model rules, certain model codes that have been drafted in order to prepare a future harmonization in Europe, they all include rules on a change of circumstances and material hardship. And of course, I would like to mention the Brazilian approach that I've already alluded to under section 478 to 480. That is also a hardship regulation that is very much along the lines that is also the development in Europe and in most legal systems. So what are the characteristics of the exceptional doctrines? First, it is clear, if you followed my lecture, that the basis of the relief is not so much the contract itself or specific defects of the contract like mistake, but rather certain extraordinary effects. The basis of relief is that the reality that the risk allocation is not the one that the parties provided for in the contract. Therefore, the exceptional doctrines go beyond the contract itself. They consider the contract to be flawless but silent in its very crucial elements, and they openly address the equity conflict between the contract and the extrinsic effects that have to be taken care of. So this open discussion, this open reference to equity is the main factor, I would say the main progress within the doctrinal development in the area of unexpected circumstances. And also the fact that we try to find the resolutions in the objective law and not in the will of the parties. And therefore, it is a fair balance between the interests of both parties that have to be found. So, having said this, we turn to the most important issues that remain. And these issues are not so much what are the typical characteristics of unexpected circumstances giving rise to this exceptional legal doctrine. The issues that we deal with much more is what are the specific remedies? What can we, how can we define a relief that is not arbitrarily shifting hardship from one party to the other, but a relief that is trying to present a balanced approach? So in this remedy perspective, it is clear that termination first comes to your mind. Like we have it, for example, in the concept of force majeure, where the obligation is just invalidated by force majeure, it's just annulled with no further consequences. So this is termination is the basic first remedy that you think of. And as we went along in this lecture, still we've seen that termination is rather flawed. Its advantage lies in the fact that it leaves little discretion to the judge. And this is why many legal scholars and some legal systems refrain from defining a mechanism of adjustment of contract, because some people mistrust judges in this mechanism of adjusting contracts. And you have to take this argument seriously, because of course this power to adjust the contract is something really ordinary in contract law, as we usually refer to the party's will. However, if you balance this risk of discretion to judges and the all or nothing approach, I suppose that from a fairness point of view, the decision to render a contract not binding cannot, in a really fair way, connect it only with termination, in order to avoid this reversal of hardship that I've talked to you very frequently about. This brings me to a very important point when we talk about legal consequences. As we went through the cases, and also through the cases that you mentioned from the Brazilian point of view, I asked the question whether or not this unexpected circumstances would give one party hardship and the other one a potential windfall profit. In this situation of hardship versus windfall profit, one may even consider termination to be appropriate. This may be one of the cases that we dealt with in Germany, where a piece of real estate was sold and the transfer of the land and the payment was supposed to be a couple of years later. And after the sales contract, after the contract, there was a inflation, and a extreme inflation that at the time at which the real estate had to be transferred rendered the value of the real estate approximately to the same as the value of a stamp for one letter. So in this case, it was obvious that at the time of the transfer, the hardship of one party giving a piece of land for the value of a stamp would be like a windfall profit to the other party, because it gets a piece of land for the value of a stamp. So this may be one of the cases where a judge would not hesitate to apply the legal consequence of termination, because the party who does not get the real estate may find this termination detrimental but it's probably not a hardship comparable as the other party incurs. So this may also be a case where it's really difficult to calculate any kind of adjustment. So having said this, it is very important to note that the alternative of adjustment, not adjustment as the only legal consequence, but the alternative to termination is extremely important. It's important for a legal system to take that step, to give the judge the discretion of adjustment. Those legal systems who have not taken this step and who do not accept adjustment as a legal consequence, for example, the English legal system that has in the doctrine of frustration no well-established adjustment mechanism, or other jurisdictions who don't take this measure, they tend to be very strict on accepting the relevance of unexpected circumstances to begin with, because they tend to avoid the legal consequence of termination, because it's just not fair to shift hardship from one side to the other. So this is a very interesting point, and that led England to, in a very restricted way, to accept some kind of compensation in cases of frustration. However, most modern jurisdictions, I mean the European jurisdictions, and for example also the Brazilian jurisdiction, accept a model of judicial adjustment as an alternative to termination. So how does this adjustment work? And here is the problem. It really does not work in a very reliable way. It avoids the all or nothing approach, and it may lead to a flexible distribution or compensation of the losses, but it's still quite difficult to discern the results and to harmonize legal adjustment with the principles of legal certainty. There are different techniques as far as adjustment is concerned. Some techniques refer to adjustment as being just an operation of the law. Some apply a right of the burdened parties to request adjustment. I suppose that this may be the solution of the Brazilian civil code, and some try to combine termination with a claim of compensation. Whatever the technique is, and I would not attribute too much weight to the technique, whatever the technique is, at the end, the fairness of adjustment always has to be decided on by a judge. And therefore, it is always the judge who has to implement this equity mechanism, whatever tool you give to the parties in order to prepare adjustment. Therefore, it is clear that adjustment means that the courts interfere with the parties' contractual dispositions, and this is why it's not accepted by some jurisdictions, but most jurisdictions accept adjustment, as I've already said. As one very interesting factor that has been discussed in the recent years and decades, and this is according to the general tendency to improve mechanisms of dealings between the parties, shouldn't adjustment be achieved by renegotiation? Shouldn't the parties be induced to renegotiate the contract in cases of unexpected circumstances? And the answer is clear. Of course, it's preferable that the parties adjust the contract by renegotiation. It is obviously a superior solution to a lengthy and uncertain civil proceeding. However, the question is whether or not renegotiation works. And therefore, whoever advocates renegotiation as a mechanism to adjustment must face the problem that the outcome of renegotiation is always open. The parties need not reach consent. So the demand that has been proposed by some scholars that adjustment should be achieved by duties, by legal duties to renegotiate, this idea has not been taken over by most of the European, and also, as I see it, not by the Brazilian jurisdiction. This is because there's no standard, no feasible standard to define what the parties have to do during these renegotiations. If at the end they can always reject the result of renegotiation, they can always come up with no consent. It is always unclear what the measure of these duties can be, how they can be made operable in a legal setting. So whenever you have duties of renegotiation, you always, as a fallback option, you need some objective definition of adjustment of contract, and therefore it may any kind of duty to renegotiate may be a suggestive measure to make the parties do what is usually good for them, but it's not a comprehensive measure to deal with the issue of adjustment of contract. So therefore it doesn't work very well. Here we have another alternative to adjustment of the contract by the courts, and this is specific statutory relief, specific statutory reactions on unexpected circumstances. And I'm uncertain whether you have something like that in Brazil. And as I've talked too much in the last hour myself, this may go as another question to you, my dear Brazilian colleagues. Is there a specific statutory regulation on contract law matters in Brazil concerning COVID? Is there?
Not yet. We will have something maybe in the next days. It's okay. With we are waiting for the sign of Bolsonaro. Maybe in the next days we will have something, but it's not very huge or a small, some few articles, a few disclosures.
Okay, that's very similar to what we did in Germany here. We did have some COVID regulation, and there have been different things in this regulation: corporate law and bankruptcy law, and also some little aspects of contract law. And as you are not into this kind of regulation in Brazil yet, my suggestion would be don't expect too much of it. But it's because this is again the issue of termination versus adjustment, and the issues of adjustment. It's really difficult to define on a general standard how one can achieve fair results under unexpected circumstances. So it's probably preferable to leave the balancing approach to the courts. Now, see, as we did it in Germany, or as our parliament did it in Germany, I do not want to identify myself with it because I don't like it. It's very punctual and not very convincing. It is first a protection of consumers who have a right of refusal under contracts that are very essential to them, and this right of refusal has the prerequisite that without the refusal they would endanger their own decent livelihood, And this right of refusal in particular refers to something like energy contracts, water contracts, and other long-term contracts that are important. This is how consumers are protected. By the way, in these cases that are covered by this special regulation of concerning consumers, we would probably not apply the principles of unexpected circumstances, because this tackles only the element of individuals who run out of money. And at least in Germany, probably all over Europe, the courts are very hesitant to address just the lack of financial resources as a trigger for unexpected circumstances relief. So this is one aspect, and a second aspect is micro enterprises, small businesses. They also get this special right to refuse performance and on long-term contracts. And also we have landlords that are not permitted to terminate leases for land on the ground that the tenant does not make a rental payment. This is supposed to protect tenants in their possession of real estate. That may make sense, even though it doesn't help too much, because it's only a restriction of termination rights. But on the long run, the tenants must pay. So it's not a full relief of the price for the lease for the time that they cannot pay, but it's only a protection against termination, which is different and of course not a long-term protection. The same applies for consumer loan agreements, where we have also a special right of refusal, where repayments and payments of interests can be deferred due to COVID if they cannot be paid due to COVID reasons. So these are basically all the German reactions in contract law on COVID at this point, and frankly, I don't see more room for a specific regulation here. I would say specific hardship regulation is always somewhat imperfect, because it cannot replace the fairness need for general doctrines for this balancing approach that has and should be provided for individually. By the way, there are still many legal scholars in Germany who are very skeptical on these unconventional doctrines like unexpected circumstances, like Wegfall der Geschäftsgrundlage, because they say the legislature should act on unexpected circumstances, and they say only the legislature can deal with exceptions to the binding nature of contract. Frankly, I think history has shown that general equitable relief is indispensable, and that the legislature is not well suited to deal with these aspects as I see it. So I would love to go on with talking about contractual provisions on unexpected events. Maybe I do this for just 1 minute, and then I may finish. Maybe can take some questions. Maybe we have to part. Anyways, as far as contractual provisions are concerned, we were discussing hardship clauses at the beginning of this lecture with M&A contracts. It is clear that they may address unforeseen events, and typically they're very similar to legal doctrines governing the issue. Usually I do not find very remarkable distinctions, and they stress the exceptional character, and sometimes they implement an obligation to renegotiate, which, as I said, does not relieve the need to define objective law standards, one may turn to the ICC hardship clause as an example for a potential contractual provision. So what do these provisions lead to? They do not resolve the problem of uncertainty. They do not resolve the problem of adjustment. And therefore, I would say we are in the same position as if we would apply general rules. And of course, like with all the other cases that we talked about, the COVID-19 is a typical example of unexpected circumstances that may potentially give rise to hardship regulation and to hardship clauses. However, this does not mean that the reference to COVID-19 by itself leads to relief, justifies relief. You always have to refer to the individual circumstances of the case. It may be that one party is not burdened enough, not excessively burdened, even though COVID-19 makes the position more difficult. It may very well be that the contractual distribution of risks is not exceeded in the case. Even though COVID-19 challenges this assumption, one has to very closely define these risk assumptions and decide on the cases individually. So at this point, I would have loved to go through the cases from the beginning again, but I suppose we are at the end of our lecture, and maybe I take the questions now, or I would take them per email. Whatever you feel better, I will be happy to do. Many thanks for this at this point. Will we take questions or do we part?
As you wish, Professor. What do you prefer?
If anybody is still awake, or maybe you're probably becoming awake right now, I'll be happy to take any more questions. We can go into the cases, we can discuss any of the aspects I talked about, or we can discuss other cases that you may come up with now.
Okay, maybe Beto, I don't know if you want to have your question. Roberto Germanos.
Yes. Good morning to everybody. Thank you, Professor Grigoleit. So to the question, is basically what could be effective to promote contracting parties into balancing private negotiations, as opposed to exceptional rules or over-judicializations on a legislative or judicial point of view? Or what could judges or the government do to promote these balancing negotiations between the parties? Thank you.
Many thanks. As I try to mention, we have in scholarly writing, we have a strong tendency that formulating negotiation duties may enhance a negotiation process and may facilitate a solution found by the parties. However, in practice, these negotiation duties have not really become any feasible tool. And this is because, in my view, this is because unless you apply a certain duty to accept a specific result, it's really easy to circumvent any kind of negotiation duty. You know, you can take part in the negotiation, but still not be willing to come to a conclusion unless you force into this negotiation a certain result. You will not get any further by trying to formulate negotiation duties. Therefore, I would say you can't do anything legally. The only thing that improves the negotiation process is the party's self-interest. And this may be promoted by the fact that the parties will try to avoid lengthy and costly proceedings, and they would like to remain in the driver's seat as far as the development of their contract is concerned. So I would say the law cannot really do anything to improve that. Thanks very much. It's a very, very important question. I wonder whether you have any better and more satisfying answers to this in Brazil. We don't in Europe.
I'm checking.
Professor Grigoleit.
Yes.
Professor Simão has asked you to go back to the first three sets of conflicts that are typical in this Corona crisis, and which answer would you give to each of those three cases?
I love that. Let's go into these three cases. I would say. Do you have the presentation on slide 5? I would say in the landlord the landlord tenant case, if the landlord rents a place to a tenant who is himself the landlord of a restaurant, I would say, and COVID leads to long-term closure of the restaurant, I would say that's a clear case of relevant unexpected circumstances, because it is inherent to the contract that the real estate, that the house can be used in the way that the parties contract for. And this is probably already in the contract, that it is to be used as a restaurant. So if the government closes the restaurant for some time, it's very similar to that. For that time, the real estate cannot be used for like reasons of a storm or reasons that the house is burnt down. So it's a risk that is not clearly on the side of the tenant, and rather on either side. So I would say it's a typical situation for unexpected circumstances that are relevant. And I would say the starting point for adjustment, that's something I had to skip in my presentation for time reasons. The starting point is always a 50-50 approach. And then you may you may come up with certain changes. For example, that the first month of closure is not an excessive burden for the tenant, so he has to take the first month completely and the rest is like 50-50. That's something that is probably up to the judges or to the parties to deal with. Also, you can probably discuss certain price elements in the contract that may be dealt with differently. But in general, I would say it's a clear case, and it's supposed to be, in my view, the starting point would be 50%. In the second case, I would say it's also quite clear, but it's clear on the other side. I would say the risk that the fitness studio can be used, that's a typical risk on the side of the business, of the enterprise that is running the fitness studio. And whether it's closed due to Corona, or whether it's closed due to hygiene issues on the property, I wouldn't distinguish that much. Therefore, I would say this is not a case of unexpected circumstances of specific relief. It's a case in which, under regular contract law rules, the customer is entitled to withhold the fee. Like, you probably have the same rule as we do. If you don't get your performance, you don't have to counterperform. And also to terminate if it's the closure is long term and it's not foreseeable that is going to end. And the third case, from the German perspective, it's rather clear. The third case, this is one of the cases that we had very frequently during war times, where delivery contracts became disproportionate due to problems in procuring goods. And if we have a tenfold increase in prices, it's quite obvious that we have an aspect of unexpected circumstances of Wegfall der Geschäftsgrundlage, and therefore we have either adjustment or termination. In this case, I would say the fair results would be that the seller, who is burdened by this price increase, may terminate the contract, and then the buyer can offer adjustment of the price if it's in his interest. But it may very well be in his interest not to contract on other terms than he has done. So he can definitely not be forced to carry out the contract on other terms. So this third alternative would be, to me, would be a case of where termination is as supposed to, for example, the first case. Termination is a rather relevant legal consequence, and legal adjustment is only feasible if the buyer accepts. Shall we go to the case that we were discussing from the Brazilian side?
Yes, all of them are very common here in our courts right now.
The energy energy price issue. I would suppose that the energy price issue is also a quite clear case of relevant unexpected circumstances, and probably unlike the case with buying medical equipment, the supply of energy cannot be given up by the customer. It is probably a matter of adjustment. I don't ask me about numbers. I don't think that 50% will be a reasonable approach here, but I suppose that we get into adjustment. How's the approach of you? How's your view on that?
Actually, nobody knows them at this point. There's a lot of discussions of people are bargaining, trying to reach consensus, but it's still a work in progress.
Yeah, I would suppose that if it gets to the courts, it'll take a very long time, and there will be differing results in court and on different levels of the court system. Therefore, it's probably extremely reasonable to find negotiating results. Maybe this would be even a case where government or parliament legislation would work well, because it's such a mass phenomenon, probably with very similar circumstances.
We are trying, our court here in São Paulo, Professor, is trying to foster agreements between parties, and we had recently a regulation on this, just trying to foster it, to incentivize it, parties to negotiate to find an agreement. And I would say that for renting, we have for more or less 70-30%, but it's a guess. I mean, we do know, as who is said, it's a work in progress. We don't know what's going to happen. We are still negotiating, and judges are still trying to give some reliefs, but the decisions are not uniform, of course. Still not uniform.
Yes, that is clear. And 70%, what do you mean with 70%? 70%?
I'm renting 30% of discount. I should.
Okay, 30%, not 70% discount, but 30% discount.
30,
Yeah.
40, it's a guess. I mean, you have a lot of different cases, 50-50, etc., but we have 30-40% of discount.
Yeah, that's very much in line with what is discussed here, and we have this rule of thumb of the German courts. You probably have the same rule of thumb, that it's the 50% rule, but only as a starting point. And I would say, as I tried to mention in the lecture, I would say 50% is the starting point, and in this case, it's probably a little bit less. So if it's 30 to 50%, that's probably what would come out, and it'll probably be so stable that the parties are probably well advised to somehow renegotiate in this range.
Our problem is that we really don't know how long COVID is going to stay, and we don't know. We know nothing about the crisis that is going to come after all of this.
Yes. Yes.
So it's just the beginning, and as you know, things in Brazil are not going very well. So we are very secure about our future, and of course, the situation reflects on our contracts and on our decisions. We don't know how long it's going to last. That's the point. The main point here. You are reopening, and we are very far away from this.
Okay.
From this reopening.
Also, it's a very, very, very good point. Also, reopening, if we talk about the businesses in question, businesses as tenants, for example, like restaurants or fitness studios, gyms, reopening for them does not mean they're making money again, because the hygiene obligations they have after reopening are really harsh. So it is, even though we are reopening here, it's still very questionable which restaurants, which studios and stuff will survive. So your question, your point that the matter of duration is still very open is very well taken, and it's probably reasonable in any kind of settlement that parties reach to keep the range of the settlement as far as time aspects are concerned rather narrow, because the unexpected circumstances that we face now will be removed by the unexpected circumstances that we'll face in 3 months.
Yes, that's it.
Christoph, Professor Rodrigo Mendes has registered a question in the chat. I wonder, Rodrigo, if you would like to address the question personally and directly to Professor Grigoleit?
I'd be happy. Hello.
Yeah, thank you. Hi, Professor. Well, it goes to section 313 of BGB.
Yes.
I wonder if I understood you correctly. Adaptation of the contract in the case of Wegfall der Geschäftsgrundlage only take place if the party apply to and make the proposal for adaptation. Is that so?
Yes, under 313, the legal consequence of adjustment is defined as a right of the burdened party. The burdened party can ask for adjustment of the contract. But still, it's not very clear how technically how this declaration of the party is to be construed. It's not
Yes.
a declaration that we call Gestaltungsrecht that directly results into the effect of adjustment. It's rather a right to demand adjustment from the other side. And this idea of demand to the other side is very much linked to the hope of the legislator that the parties will somehow come to a renegotiation agreement. But at the end, when the dispute becomes controversial and the courts will decide, this mechanism of asking for renegotiation or asking for adjustment, this mechanism is not very relevant, you know, because at the end, the court have to say what is the fair result if the parties have failed to come up with an agreement. So this is something I tried to point out in the middle of the lecture, that these different mechanisms of applying adjustment, they, in their distinctions, they don't really differ very much. At the end of the day, you have to come up with something like an objective idea of what is fair, and this idea has to be implemented by the courts. And the parties in their procedural moves somehow have to anticipate the potential result because they have to claim something before the court. But at the end, the court will decide.
And following one question, is there any objective or any criteria for the judge to assess whether the party proposal should be enforced or not? Or is just a decision based on the fairness, on a somewhat discretion? We rely upon the discretionary of the judge.
We have under German civil procedural law, probably like in Brazil, we have the principle of ne ultra petita, which means that the parties in their procedural claims have to identify what they would like to have, and the courts cannot go beyond that. So the claim of the burden party, for example, maybe even the other party, either party can be in the attacking position in court. Either party defines by their claims the extent, the potential extent of adjustment. But within the scope, it is like a solution that is ideally provided by objective law, but practically with a large margin of discretion by the court.
Okay, thank you.
I may add that this adjustment issue is even more complicated by the fact that it's not always only an issue of calculating a financial compensation.
That's true.
It may also include adapting certain obligation as they are, in brackets, naturally defined by the parties. So it may even be more complicated. And under German law, we have a wide margin of discretion left to the courts. And I think adjustment does not work without such a margin. It's just the idea. And even though we all feel unwell with giving judges too much power, it's probably the least of certain alternative problems. And the even bigger problem is that with very certain and exact legal consequences, you will never reach fair results. For example, like termination rights.
Thank you.
Many thanks. Very, very interesting question that went to the core of the problem, and probably from to the core of the unresolvable problem of legal adjustment. And we have called this in our book, we have called this the mystery of adjustment, because we think that all the issues somehow relate to the uncertainties that are caused by the mechanism of adjustment, and they cannot be circumvented in a satisfying way. You just have to, make the step to accept court discretion.
Okay. Professor, we have a last question from our student, Luisa Teles. Luisa, I think you would like to have your question here. Luisa?
Hello? I don't know.
Hey, Luisa.
Hello, hi. I don't know if you can hear me properly.
I
Good morning.
hear you very well.
Okay, so my question stands to this topic. I would like trying to find some criteria for judges to adjust the contracts due to hardship. I would wonder if in this business-to-business relations, should the financial statement of parties, of the companies, be a type of criteria? Not just the financial statement, but in means of the actual possibility of the companies to fulfill their obligations.
Yeah, many thanks. We have a discussion on that under German law, and we have some court decisions that base their equitable decision on the notion that if there was no equitable relief, one of the parties, maybe one of the businesses, would face ruinous consequences. So, and this ruin somehow has to refers to the financial status of businesses. So, the first answer to this question is yes, this has been a factor. The second question is, it's not an obvious point, because the financial situation of an enterprise, of a business by itself is nothing that is beyond the business's risk or beyond the business's responsibility. So it can only be one aspect within additional corroborating aspects that lead to the conclusion that any kind of ruinous consequences, even though in general they may be disregarded, are relevant in the context of the specific circumstances of COVID-19. And I suggest that in the context of COVID-19, the courts implicitly or explicitly will definitely refer to the aspect of potential ruinous consequences. In particular, the German legislature has managed to change the laws of bankruptcy, and I suppose that in contract law, this tendency to protect from bankruptcy will be a factor too. Very good question. Many thanks.
Professor, I think Professor Satiro, his students are here with us would like to address you a question. Professor Satiro, please.
Many thanks, Professor Satiro. I'd be happy to answer.
Thank you, Professor Grigoleit. It was a brilliant lecture. Thank you for allowing us to enjoy it. Our legislators here in Brazil are putting all their hopes in negotiation and mediation as a solution for the crisis. We had some recent rules that have been discussed in the courts, in the legislative, about mandatory negotiation, mandatory mediation, or even a kind of standstill in order for parties to negotiate solutions. I thought you were a little bit skeptical about it, And I'd like to know your opinion about choosing negotiation as a way of solving that kind of problem.
Yes, many thanks. It's a very good question, and also it's very correct that you drew a skeptical view from my lecture on this point. Even though it's if we do not talk about legal duties to negotiate, but a legal duty to mediation, I would be a little bit more differentiating. But I'll come to that later. First, I would like to say we do have in Germany some legislative tries to improve and facilitate mediation, and in some instances even make it mandatory. But this tendency has not been very strong and very successful. And in our context, with regard to COVID-19 and unexpected circumstances, we have two different directions that have to be balanced. The one direction is that as adjustment is always involving a wide margin of discretion to the courts, it's probably a good idea not to have too many courts to decide on the same case. So the regular course of a civil dispute between different courts in the hierarchy of courts, this course of many decisions, that seems to be, particularly in this case, very complicated and leaves the proceeding even more uncertain. So that would be a question. That would be an argument to make mediation or arbitration mandatory in these cases. On the other side, the experience is that if you only have like something a preceding mediation procedure that is mandatory before the regular civil proceeding, the experience in Germany is rather negative. It is the experience is rather that if the parties are willing to mediate, they will already have renegotiated the matter, and they do not need a proceeding of mediation. As we already mentioned, there are incentives for the parties to decide on renegotiation by themselves. They don't need to be forced to negotiations. So this coercive mediation is not always very fruitful. And to make it like coercive arbitration, like a proceeding that will definitely decide on the case, that will at least prevent the complexity of a regular public proceeding with the hierarchy of courts on the one side. On the other side, sometimes it's not even cheaper than a public proceeding. And our experience is that it's not that the parties are not, at least not clearly, in favor of arbitration instead of public civil proceeding, because civil proceeding may even be cheaper. There may be some other reasons for the civil proceeding. So I wouldn't go for a coercive arbitration proceeding. But final point, that is a different aspect than duties to renegotiate, right? These are different aspects, because duties to renegotiate only try to somehow steer the process of private renegotiations. We do not have a specific proceeding with a mediation actor. where a mediation actor is concerned. So far, many thanks for the very good question.
Christoph, I'm afraid we have to finish. We had a wonderful time. There are many questions still left. This was not only a very elucidating lecture, but it was also a fine example of scholarship, very inspiring for all the students, for all the professors here. And I know the depth of your knowledge of law, of many fields of law, and I definitely believe that this deep knowledge of the law allows you to give us such a clear and systematic presentation of all the relevant issues involved in the Corona crisis. Thank you very much for your help. Have a great lunch there in Germany in a beautiful spring afternoon in Munich. And thank you all for being here for 2 hours with us. And I do recommend Professor Grigoleit's book on unexpected circumstances, change of circumstances in contract law in Europe. Thank you very much. Paula, I think we all have to move to the other classes, right?
Yes, Professor, thank you. It was a wonderful time here with you. Thank you, Rui, for bringing Professor Grigoleit to us to have this wonderful time. We all learned a lot with you, Professor. It was a very instigating exchange of knowledge. Thank you very much for sharing with us your knowledge, this knowledge that Rui was referring to. Thank you very much. Thank you to all professors that are here with us, our friends, and especially to our students. And on my behalf, on behalf of Commercial Law Department, I do thank you very much. So have a great day.
So the burden of thanks is completely on my side. I had a wonderful time with you, very inspiring questions. I always enjoy the exchange. I'm looking forward to meeting as many of you as possible, as soon as possible in Europe, maybe even in Munich. Maybe you can give me an email address where I can send my presentation to, so that we can make it available to the
Oh, thank you very much.
Also, as you were talking about my corporate law book, we have just prepared a new edition. If there is anybody like you or others from the commercial law side who are interested in it, we'll have some copies to distribute to Brazil for free. Let me know.
Thank you, Professor.
But I have to warn you, Rui said last time it was 2,300 pages. Now it's 3,300 pages.
That's great.
Beware what you do.
Thank you, Professor.
It
So,
was my pleasure. Thank you very much for having me.
thank you. Bye-bye.
Goodbye.
Bye-bye.
Thank you.
Thank you very much.